Adventure Credit Union versus Michelle Long. I've got Jen R. from Adventure Credit Union. What's your name? From Adventure?
Jennifer Roy, R-O-Y.
What's your position with Adventure?
Financial restoration.
And are you Michelle Long?
Yes, sir.
This is a claim for $3,887.85 plus costs for a loan that Adventure Credit Union made to Michelle Long on a vehicle that was repossessed. This is a shortcoming, I believe, after the vehicle was repossessed and sold. Ms. Long, what's your position?
Well, at the time when it was repoed, I went in with the money to get it out, and get it paid for. But I didn't have 500. I was minus 500, and I asked and pleaded with Adventure beforehand. I just got a job at American Axle, and I was waiting on my next paycheck, which was 2 days to come in, and I could get it all caught up. They refused to help or assist in any way. So I had to leave the car.
Well, Ms. Vaughn, Ms. Roy, what can you tell me about this?
So it looks like we did receive that call from her regarding wanting to pay a partial amount, or wanted to from the notes that we do have, is stating that she wanted to do a payment arrangement, did not specify specifically any date that she would have additional funds, but did state that, that she only had so much amount of funds. We did specify that it was our manager's decision of what she needed to pay in the certified funds, along with the repo cost to the repo company, in order to reinstate the vehicle and get the vehicle back. After that, we did not hear from her. That was on 11/10/2023. And then on the 22nd, our repo company, which is M&W, they emailed us asking if we could file the claim regarding this and move forward with it. So we hadn't heard back from her since then. So, I mean, we don't generally just say, no, we're not going to take. Can I finish, please? We don't generally.
Just a moment. Ms. Long, we're in court. We're not sitting around the kitchen table. So she'll finish what she has to say, and I'll give you a chance for what you have to say. Ms. Roy, I don't know anything. Yeah. There isn't a copy of the loan. I don't know what kind of car this was. You simply filed some bare bone pleadings that said this money is to. Let me see if I'm missing something. No, it's not much here. So how did you come up with this figure for $3,887.85?
That was what was left to pay on the vehicle after we did all gap claims and any type of insurance that we could get.
All right. Well, it's one thing to say it in a lump, but what's the calculation? I don't know what kind of car it was. I don't know how much the loan was. I don't know what the interest rate was. I don't know when it was repossessed. I don't know how much the car was sold at. Which in general civil, we generally have that stuff, but this is small claims.
Over 2 years ago.
Yes. Probably a pleasant surprise when you got this lawsuit in the mail.
Yeah.
Statute of limitations is 6 years. They say 3,887.85 is due, but I don't know how they came up with that number. Do you agree with that number or disagree?
No, I disagree because I told them at the time when I came into the office there and I talked to them, I told them that if I can't get it out today, to do what you had to do to get rid of it, because I couldn't come back. I don't even have the job at Axel anymore. I'm living in a motel room. Okay, I can't find a place to live right now because I have an eviction on my record. So nobody will rent to me. I work at Walmart and I just got a full-time position. Yesterday, I started my first 8-hour shift.
Good for you. All right. So anyway, I'm buying a pig and a poke. I don't know. What kind of car was it?
It was a 2011 Malibu. It had maybe 85,000 miles on it. Maybe a little more.
How much was the loan for?
The original
not
balance was for $13,690.94.
All right, so the loan was for $13,690. Ms. Roy, you probably didn't start this loan. Somebody probably handed this to you and said, sue this lady in small claims court. Well, you need
Yeah,
more than this. By the way, she owes us money. So, all right, the loan was for $13,680. What was the balance due at the time it was repossessed?
let me take a look at that.
I would have had it paid off by now if they would have let me take it.
Yes.
At the time that it was repossessed, it was, looks like for, oh, sorry, minus the proceeds there. So let's see. This was 2023 was the last check that or payment that we received. $10,691.41.
What was the
And
date of that?
that was on 8/25/2023.
All right, and then it was repossessed.
Yes, and it was sold at M&W auction proceeds, and we did receive $5,809.75 for that. And then we also received funds for a gap claim for $1357.58. So that's when we got down to that amount as well.
I've said this before. These are my perhaps least favorite kinds of cases.
I
of
can
all.
imagine.
Aftermarket auto loans, the cars are sold. Was this part of a car dealership or was this a separate loan company?
Correct. It was a dealership. We only provided the loan to the member.
Who is the
to
dealership?
Miss Long. I don't know. Let me
Who
take
did
a
you
look
buy
here
the
at
car from, Miss Long?
I went to the dealership in I think it was
Charlotte.
Lansing or
Well,
Charlotte.
Mhm. Yep. It was a Team 1 Chevy Buick GMC.
all right. And Adventure was simply the loan company.
Yes, sir.
These are better than where they're selling cars at a prior price because people are credit challenged. They have interest at extremely high rates. They're repossessed. The cars are then sold at auction for $5,800. Then they wash it and then sell it for $10,000. In the meantime, she's on the hook for the rest. It appears, as a record was supplemented, that on August of 2023, the shortcoming on the vehicle is $10,691.31. When you told them, do what you gotta do to get rid of it, I guess you gave them the authority to sell this. They sold it at auction for $5,809.75 plus some gap coverage, so let's add that up. 5809.75 plus 1357.58 is 7,167.33. So if we subtract 10,691 minus 7,167.33, we get 3,523.98.
There's also interest in there, Your Honor, when we did the charge off. The interest that was due at that time was $368.77.
Give me that, please.
$368.77. The total loan balance that we have was $3,519.08. I didn't recall what you said. I apologize.
Well, I got 3,523.98.
That's close, yeah.
Anyway, these are very poor pleadings, even if it is small claims. She's entitled to know what it is that she owes and how it was calculated. But we are in small claims. The rules are more liberal. If this was a general civil case, it'd probably get bounced.
Your Honor, I do apologize. We did send her final letters regarding what the balance was at a couple of different times. So
I haven't been getting my mail.
If she has
I
moved, yeah.
live in
wait
a
a minute.
motel room.
All right, same thing, just wait. I don't have to like it. The other fact is they then waited 2 years and they laid this on her desk and hey, said file a small claims action for this. So I don't really like much of it at all, but I don't have to like it. Um, $3,523.98 plus $368.77 in interest is $3,892.75. Close 3,887.85. Your number is actually lower. This long, I'm sorry. You just think you're getting somewhere. You get a new job, you're at Walmart, you got full-time employment, and blammo, you're paying for a dead horse that you don't own anymore from 2 years ago.
I've been without a card for 2 years. I walked over a mile back and forth to frickin' American Axle.
Well, I wouldn't call it frickin' American Axle. It's probably actually one of our better employers. It's hard work, but it pays well and has decent benefits. Yeah, I don't know what the decision was. They weren't willing to take a partial payment. So they took your car, sold it for half of what you owed on it, sued you for the rest. Doesn't seem fair, does it?
I have no way to pay that right now. I really don't.
Well, that's fine. It's just a judgment that says you owe money. They can attempt to collect. Right now, you're one step away from homeless and just got a new job. However, this judgment's good for 10 years. I'm going to use their figure, which is lower than the one I calculated. There's also court costs of $86.25 filing fee and $68.19 service fee total of $4,042.29. And right now you're in room 128 there on 131.
Yes, sir.
And that's close to work, so that's good. The problem is it's very expensive. You're probably paying over $1,000 a month for rent.
I pay $360 a week.
Yeah, that's a lot. Let's see what that is.
It's around
Times.
$1,400 a month.
Yeah, that's a lot for a motel room. I don't know what to say, but right now you're not in a position to make a payment agreement.
I worked at American Axle for 2 years. I just got fired over Christmas.
All right, I'm sorry about that. Were you in the union?
Yeah,
It's hard to fire somebody in the union out there. I'm not sure what happened, but at any rate, I will send you this. You owe this amount of money. If they do try to collect or garnish your wages, you can file what's called a request for installment payments. If you get a garnishment or something, you contact the clerks. But I find by the preponderance of evidence standard necessary in small claims that they met their burden of proof through sworn testimony, barely, that you owe that amount of money. All right, I'll send you a copy of that, and we'll send a copy also to Adventure Credit Union. I guess it was an adventure, but not a very good one. All right, everybody, that completes that portion, and I wish you luck this long.
thank you.
Okay. Thank you.
Thank you.
This has been filed as a termination of tenancy action for a fraudulent application for tenancy. Mr. Bush has filed a complaint and supplemental information indicating that the defendant had previously, in fact, been evicted and failed to disclose that. I recall those cases. The name certainly is familiar to us. She is the former daughter-in-law of attorney Robert Dutka. That marriage is over. She retained the Dutka name, but she's not related to attorney Dutka. She was filed an eviction case in 2024, 2 and 24, and an earlier one in 25. So she had 3 previous termination of tenancy cases that she failed to disclose. Is that correct, Mr. Bush?
That is correct. That is our understanding of it. I believe I mentioned those in the complaint. Yes. The amendment to the complaint, I listed those.
Miss Lamont, I note she was served by attachment. Is she there?
Is she still in?
To my understanding, yes.
Have you had any communication with her?
I have not.
Let's look at Sergeant Morse's notes. Because she was not personally served, I can't do a default. I don't have a second mailing. So we're going to have to adjourn this for 7 days. Let's see what Sergeant Morse says about service.
What is good?
12:30, looked out windows. No answer, left card. Not home per Kyle Wergow, who apparently was there. So her boyfriend may be there. So yeah, they may be in possession. At any rate, she is not here. We don't have personal service, so I can't do a default. So Howard, we're gonna have to continue this to February 2nd
Yeah,
at 1:40.
pardon?
At 1:40, does that work for you?
Yes.
That'll work. February 2nd is a Monday.
Yes.
Yeah,
Yes. If she appeared, I'd have to give her 7 days. She didn't appear, but we don't have personal service, so she gets 7 days. We'll revisit this on February 2nd at 1:40 PM. I'm not sure what happened in the other cases, whether there was an actual termination of tenancy, writ, or she moved out voluntarily. I can't remember. It seems to me in at least one or more of those cases, there was a writ. At any rate, we'll revisit this next week, February 2nd at 1:40.
and I would note for the court that she has not paid anything since the deposit on the lease.
Pretty good deal. She can't pay rent on a termination of tenancy case. So if we meet next week, she'll get 10 days from that date. So stretching it out as long as possible would take till February the 12th to get her out of there. But we'll see what happens next week. Thank you.
All right. Thank you.
This is file number 252219SC. It's a small claims case, or at least it started as one. The original title of the case is Savannah Salmon versus Ron Neal. We had a hearing on November 17th. And the defendant was here on November 17th, as was the plaintiff. In the meantime, his insurance company, Mr. Neal's insurance company, has filed an order removing the matter to the general division of the court. That was filed on January 9th. So the matter's been removed by your attorney, who is on behalf of the insurance company. They filed an appearance on your behalf.
Really?
Kelly M. Mann, Quateros, Prieto, Wood, and Boyer, PA, from Novi. They filed a motion to remove the matter to the general division of the court, and then they promptly didn't file an answer. So that you're subject to default for $3,000. So I'm gonna set this matter for entry of default. I would suggest you call them and ask what's going on. I'm gonna have the court officer take you out, give you a copy of that, but they did file an appearance listed as your lawyer, remove the matter to the general division of the court where small claims rule don't apply, but the real rules apply. And they're supposed to file an answer. It says right here within 14 days, which would have expired January 25th.
I wasn't aware of all that.
Probably not. So we'll give you that. You call them and say, hey, what's going on? I'm about to get defaulted for $3,000. We'll set it for hearing regarding the entry of that default and see what happens. All right, I expect somebody will wake up and file something. But you go and get a copy of that so you know what they did.
Go with him?
Yes. Is LVNV funding versus Dorothy Brown. This is file number 251822GC. Ms. Brown, can you hear me?
I can.
This is also a motion for summary disposition. With costs, the total would be $3,231.09. Once again, the lawsuit was served on the defendant and defendant filed a response. In this case, the defendant is asking to compel arbitration proceedings under the contract, she contends that it does allow them to stay this matter and refer for arbitration. Mr. Jamal, what's your position there?
Typically, anytime somebody requests to compel arbitration, we don't necessarily object to that request. We just request that the defendant, being the one who's electing arbitration, be the one to actually go forward and file it. There are other requirements regarding who covers the costs, et cetera. But since we are not electing, we typically request that the court order that the defendant be the one to file.
All right. Is that agreeable with you, Ms. Brown?
Yes. Your Honor.
Are you willing, short of that, to discuss this matter with Mr. Jamal for perhaps some sort of settlement agreement?
As far as I know, it was supposed to be done through an arbitrator.
Well, that's an option. And you've submitted it, and you've even submitted an order referring it to arbitration. I would order that you be the one to file for the actual arbitration. And so he's not even objecting to that, as long as you're the one to do it. But you're here and he's here. We could let you talk to each other in the meantime. Let's take a break and see how we're doing with Mr. Rognus and Mr. Barta. Mr. Barta, you're the plaintiff. I'll defer to you. What's our status here?
Your Honor, we've resolved it with a settlement amount, which is going to be paid. It's $350 to be paid on or before March 26th, 2026. I don't know if the court wishes to just adjourn our motion and pretrial out till after March 26th, and then we can file a dismissal with prejudice once that's paid, or do you want us to get a settlement document together into the court?
First option is easier. Mr. Rognus, do you agree with that?
Yes, sir, Your Honor.
And if I defer this to March,
You might want to pick it up into April.
April 6th,
Yeah.
2026, maybe the snow will be melted by then at 1:45. Expect settlement and dismissal.
Correct, Your Honor.
All right, let me make sure I nail this down. The claim is for $674.37. The defendant agrees to pay $350. Is that inclusive of costs?
Yes, sir, Your Honor.
Yes.
Mr. Hayes, you agree to that?
Yes. Sir. Sir.
You're gonna pay that before March 26th, which is 2 months from now. If that is paid, plaintiff will dismiss with prejudice. If not paid, we'll have the hearing on the summary disposition motion on April 6th at 1:45. Is that acceptable to you, Mr. Barta?
It is, Your Honor.
All right, thank you. And thank you for logging in and discussing the matter. I'll see you next time. You seem to
Have a
come
great day.
a couple times a month as punishment. They send you out here and maybe one day you get to come here for real again. All right, I'll see you next time. Thank you.
Thank you.
All right, same thing with Mr. Jamal. He comes out here a couple times a month, whether he wants to or not. We were talking at first about Dorothy Brown. And she was requesting mediation or arbitration, which defendant does not object. We're going to table that one for a minute. We're going to put Miss Merriman and Mr. Jamal in a breakout room, and then we'll make a record on Mr. Rognus's discovery. So Miss Merriman, I'm going to assign you to a breakout room. When you see the button that says join, click on that and I'll put you in with Mr. Jamal and you guys can discuss this matter and this motion. You've apparently made an offer, and you guys can discuss that.
Thank you.
So you should be good to go if you just join it. Oops, yeah, you're good.
Okay, thank you.
Judge.
All right, Mr. Rogness has also filed a discovery subpoena in the matter of Arden Davidson versus Joe Kemp. The file number here is 252140.
2104.
2104, yes, thank you. The judgment is substantial for district court terms, $15,000 plus costs for $15,292.80. Judgment entered on October 28th of 2025 by default. And an attempt to collect on that debt, Mr. Rogness has tried to garnish some bank accounts and other things. He filed it for a debtor examination for today. And that is Monday, January 26th at 1:45 p.m. That subpoena was personally served by Adam Kraft on January 14th at 4:45. The defendant is not here. Let's call. I don't have you to yell the hall 3 times, Andrew, so I have to call
That's
bailiffs.
true. I could yell, but it's not going to do any good.
Hello, Deputy Broker. I'm looking for Joseph Kemp, who's supposed to be here on a discovery case. All right, thank you. Bye.
Request a bench warrant, Your Honor.
Plaintiff. Defendant failed to appear for discovery. Personal service. It is snowing like crazy out there. It's 4 degrees and all the schools are closed. There may be a reason why he isn't here.
Yeah, but he's had my phone number this entire time.
Say that again.
He's had my phone number the entire time. Certainly could have got in touch with us when he got the garnishment disclosure.
Well, he has not. Let's see what we're gonna do. I'm gonna set an order to show cause first.
Okay. What date you want it?
I'd like to do it next Monday. Let's see if you're here for anything.
What's the date next Monday?
It's Monday, February 2nd.
Okay, then. Is that bar meeting on that day?
I think so. No, second Monday of the month.
Okay, okay.
Apparently, Matt Davidson was working on a nice meeting. It doesn't look like you're set for anything, Andrew, but we can
It's gonna
set this
be
for
by
1:45,
anyway, so-
February 2nd. Does that work for you?
February 2nd, 1:45, you said?
Yes,
By Zoom?
yes.
You're gonna send the show cause order out?
Yes,
Okay. So I don't have to do anything? The clerk will do that?
yes, you just need to show up. If he's not here at that time, I will entertain your motion for a bench warrant. So if anybody knows Joe Kemp from Sturgis, I'd advise he call Mr. Rogness. His phone number is written all over Sturgis. It's in the book. It's in his pleadings. And otherwise, we'll have a show cause hearing next Monday at 1:45. And if he does not appear at that time, I will entertain Mr. Rogness' motion for a bench warrant.
Good enough, thank you.
All right, thank you.